Wait, we have a whole bunch of people that are connecting. I'm going to... let me know, Kristen. Okay. Hi, good morning, everyone over at the jail. They can't or they can? They can't. Okay. Hi, Miss Roger. And who are you here for this morning? Okay. Okay. Is anyone over Zoom here for Mark Bolio? And this is Mr. Fayette's case. Miss Rogers in the courtroom. 20 CF 957 and 20 CF 1064.
Yes, Your Honor. Kate Rumley appearing for the state.
Okay, waiting for our state attorney to chime in. Who do we have for the state for Mark Bolio?
Your Honor, Kate Rumley for the state.
Uh-oh, hold on, Miss Rumley. Can't hear you. I checked these speakers yesterday. I swear I did. Why can't I hear her? There we go. Open sound settings.
Your Honor, can you hear me now?
I can't hear you at all, Miss Rumley. Okay, say something again.
Can you hear me now?
No, I can't hear you at all. It's very strange.
Can you hear me now?
A little bit better. I've got my thing on maximum volume right now. I've got the speak. Somebody else over Zoom say something. I want to figure out if it's me or if it's Miss Rumley. How about Mr. Nagel? Why don't you chime in?
Hello, Judge. Can you hear me?
Yeah, but it's just really super low today. I don't know what's going on. All right. Well, I may have to repeat some stuff this morning. All right. Ms. Rumley, there was a request. What is it? The request is that there's a competency evaluation that's pending. We're going to set this probably on another complex case management docket. Yes?
That's fine, Judge.
Okay. That's okay with the state. So where do we want to set it? It looks like we're looking at for complex CMC, February 26th or May 7th.
Judge, I would request the May 7th date. I think that will give us time to have the evaluation done and hopefully have a report generated.
Okay, you're looking at the May 7th date too, is that right, Ms. Rumley?
Yes.
I don't know what the heck is going on here. This was working great last night, but I can't hear anybody this morning. I've got it all the way maxed up on the speakers. Let's try it with the computer. I'm unplugging the speakers. Let's see if we can hear you now. Say something, somebody.
I can't hear anything Miss Rogers is saying. I don't know if it's
the speakers. There's something wrong with the speakers. Okay, Ms. Rogers said that there is a pending competency evaluation and she was looking to continue the case management and she would prefer that it go on May the 7th.
That would be perfect.
That works. All right. So that's what we'll do with that case. Thank you.
And Judge, I would ask that both of his cases track each other.
Yes, we'll set both of them for May the 7th. Okay. And Ms. Roger, you said you're here for a plea at 9:30, right? You don't have anything else? Okay, perfect. All right, let's see who else do we have over Zoom this morning. Mr. Youngblood, are you here this morning for a 9 o'clock or are you here on a 9:30?
I'm here for 9 o'clock this morning. Good morning, Your Honor. It's Kent Kaji.
Haji, yes.
Horowitz for the state. Good morning, Your Honor.
Good morning. This is 20 CF 1067. And what are we doing for Mr. Kaji this morning, Mr. Youngblood?
Good morning, Your Honor. Move to continue waive speedy trial. I just filed the notice of appearance a week or two ago. Just received discovery today. Probably like to request a 2-cycle continuance.
That would be May 7th.
The state has no objection for a 2-cycle continuance. I would note, though, that I don't believe I've had a notice of appearance by Mr. Youngblood. I do have a notice of appearance from Mr. Muska's office, having been a stipulation taken over from Mangone.
I see Greg Mangone as the attorney of record on my docket.
There was a stipulation filed for Mr. Muska's office. And then I did see that there was something by Mr. Youngblood, but I didn't see that there was full documents. All that said, I did receive a call from Mr. Youngblood yesterday, which I just got today.
Hold on a second. So there was an order on January the 1st allowing Mr. Roystacker to withdraw. And then that was granted on January the 4th. However, Mr. Youngblood filed his notice of appearance on 12/29. So it looks like, Mr. Youngblood, that your notice of appearance preceded the order granting the withdrawal. So I don't know how, if we want to just put it on the record now that you are counsel of record, Mr. Youngblood, and that the court would grant your request to appear on his behalf, because it just seems like your documentation just was filed a little bit later. So I don't have any problem fixing that on the record. Because it does appear yes, ma'am.
If I may, Your Honor, now I would just request that Mr. Kaji appear, whether we're by Zoom or in person, because there seems to be some confusion as to who is actually representing him, because now I'm getting conflicting information that perhaps Mr. Youngblood and Mr. Muska's office have representation.
My understanding is that
there is an order in the file on January the 4th granting the Muska law firm's request to withdraw. So they are off this case. The question is, with Mr. Youngblood's notice of appearance having been filed 5 days prior to the order granting the withdrawal, should we just simply have Mr. Youngblood refile his notice of appearance? If that was the record, I'll have you do that.
Judge, I'm confused about that order of January 4th granting. It sounds like you're saying that Muska was granted withdrawal. That's not my understanding. My understanding is that we both concurrently represent Mr. Kaji.
That's not what happened. I'm looking at the order myself. The order says, Bruce Roystacker of Muska Law is hereby substituted as counsel for the defendant in the above captioned case, and Gregory Mangone is released from all legal duties. So it's a little confusing. Because
right, so
which is
so
why
Mr.
the state would
Mangone is off.
respectfully. Go ahead, Mr. Youngblood, if Your Honor pleases.
So Mr. Mangone is off, Muska is on, and then I filed my notice of appearance. As far as I understand, Mr. Kaji wants both the Muska firm and me to be on the case. And I have Mr. Kaji standing by, ready to appear right now on Zoom if that's what the court would like.
It's just unusual. I've actually never seen it done this way. I just want to make sure that it's proper so that we have both attorneys on as co-counsel. And Mr. Youngblood too, that they are going to be co-counsel, it appears. Okay, so the clerk says she can fix it so that it's taken care of. All right.
And
Do we still need Mr. Kaji online? Do you want to have him sign in? Let's have him sign in and we'll hear from him.
Okay, I will call him and he'll Zoom in.
Okay.
Thank you very much, Your Honor. While that is occurring, I would note that Mr. Mangone did conduct multiple depositions. I don't know quite how many still remain. I had started conversations with Mr. Mangone about a resolution.
Okay.
So we've
So
kind
I
of
guess,
been.
Mr. Youngblood, the question would be this: you all are going to be co-counsel on this, but who, is the state going to have the primary conversations with about, maybe perhaps resolving this or, so that she knows who to call or do you want her to,
That would be me.
It's just a little unusual.
It is a little unusual, Judge. I appreciate that. That would be me.
Very good. That's very helpful, Your Honor. And if Your Honor pleases, can Your Honor tell me that there was a waiver of speedy trial, please?
Yes, there's a waiver of speedy trial on October the 9th of 2020. I'm seeing it in my in my history.
Thank you. And Your Honor gave us the
Hold on one second.
CMC.
What was the question? Yes. So what do we do about the fact that Mr. Roystacker has now retired and he's no longer with Muscalaw? Are they going to, and I actually asked Mr. Caro this yesterday, whether they were going to kind of clean up their files since the attorney has left and now we've got to find out who's going to be of record. Because he apparently has left the firm, Mr. Youngblood. I'm sure you were aware of that, right? I
was not aware of that. I haven't heard from the Musca firm, but I just advised Mr. Kaji that he should touch base with them.
Okay. Well, we definitely need to have somebody from the firm substitute for Mr. Roystacker in all of his cases. And we're getting Mr. Kaji on, is he one of these phone numbers down here by chance?
No, but I have to send him the Zoom link, which I'm working on right now.
Okay. All right. So why don't we just pass your case real quick until we can get Mr. Kaji on, and let's move on to someone else.
Very well.
Let's see, Mr. Cantor, I see you on Zoom.
Good morning, Your Honor.
Good morning. 20 CF 1101. What are we doing for Mr. Batsios, sir?
Your Honor, I have 7 depositions scheduled for February 1st. I have discovery, but I don't have the forensic report, and I'm going to need that forensic report before I take those depots on the 1st. So I'd ask for a continuance to a March case management conference date. Assuming I have the forensic report before the February 1st date, the depots should move forward. And if not, I'm going to have to reschedule them, and we'll come back in March and explain to the court where we are.
From what I see on Judge Manuelich's case management conference dates, the next 2 dates are February the 26th and May the 7th. So are you looking for that May the 7th date, sir?
I would, Your Honor. This is a complex case, and we're going to need that additional time.
Any objection from the state?
No objection from the state. Mara Marzano on behalf of the state of Florida, by the way.
Thank you, Ms. Marzano. Okay, so we'll set that on May the 7th.
Thank you, Judge. What time is it on May 7th?
9 a.m.
Thank you, Judge. Have a wonderful day.
Thank you. You too. Okay. Mr. Hopkins, you here for Mr. Allen, 20 CF 404? And Mr. Hopkins is approaching. He's in the courtroom.
Oh, okay, because I did call over to Mr. Berry's office, Your Honor, to make sure someone knew about it, because I didn't get him on the Zoom call. Mara Marzano for the state of Florida.
Can you hear Mr. Hopkins? He's in the
No,
courtroom.
I cannot hear him, Your Honor.
He said thank you for the phone call.
Okay.
I feel like it's the game of telephone with this whole Zoom mask thing, with everyone over Zoom and some people in the courtroom and people over the in the jail over there. It's just hard to hear sometimes. But what are we going to do for this gentleman, for Mr. Block?
We've done some depositions, not a whole lot of them. We need to continue to work the case. So my request would be that we put it over to case management at the end of February.
The case management in February is February the 26th. Does that work for you, Mr. Hopkins? Okay, perfect. We'll set you for February the 26th then. Thank you.
Thank you.
Block.
Nice day.
Oh, did I call the wrong one? I'm so sorry. I did. Sorry about that. I said Block and it should have been Allen. Case number 20 CF 404. That's the one we were addressing. I am so sorry. Thank you. Good morning, Mr. Khalil. How are you today? Good. I am, yes, but we're not quite ready yet. All right, do we have, Mr. Nagel? I thought I saw him this morning. Mr. Nagel,
I'm
you
here.
have, Kenneth Tennessee, 20 CF
Yes.
1115.
Yeah, I'm here, Judge.
And what are we going to do for Mr. Tennessee this morning, sir?
Mr. Tennessee, Judge Mangulis has signed an order for a competency evaluation of Mr. Tennessee by Dr. Collins. We need to get the report back on that before the next step. Mr. Tennessee is also under a commitment for a Baker Act. The Department of Children and Families is waiting for the results of the competency evaluation before they determine where to send Mr. Tennessee at this point.
Okay, so are you looking for another case management, maybe
Yes.
End of February or beginning of May?
End of February. Why don't we try there and see, make sure the report should be done by then.
Okay.
The evaluation's already been ordered, and we can proceed from there once we get that order in hand.
So you want to put him on the February the 26th date?
Yes.
Any objection from the state?
Deborah Cunningham for the state. No objection to that date, Your Honor.
Thank you. All right. So that will be February the 26th at 9 a.m. Now we're going to call Mr. Block, and this would be Mr. Tompkins' case, 18 CF 833. Mr. Tompkins?
Good morning, Judge.
Good morning.
Judge, this case has been coming up every 6 months or so. Mr. Block has already been found to be not competent to proceed, and 2 experts have found that he's non-restorable. He's 80 plus years old with dementia and Alzheimer's. So I've spoken to Ms. Mason, and I believe that the state's position is to, they've got their statutory time frame to wait this out before they have to dismiss this case. So Judge Manlich has been setting it every 6 months, and we're here for that 6 month update.
All right. Do we want to set this June, July? I've got June 11th or July 16th.
I prefer the July date, Judge.
Any
Morning, Your Honor.
objections?
Laura Mason on behalf of the state, and the state has no objection to setting it for July for a status.
All right. So we will set this for July 16th for status. Thank you, Mr. Tompkins.
Thank you.
Your Honor,
Are we ready with Mr. Kaji? Is Mr. Kaji over Zoom yet?
I think he's in the waiting room.
Oh, he's in the waiting room? Uh-oh, I don't really actually know how to get him out of the waiting room. I don't see anyone in any waiting room. Because when I look at, I don't even know that Judge Manuelich has enabled the waiting room feature on Zoom because I don't see it.
He says he's getting a message saying it starts at 1:30.
He's on the wrong,
Oh,
might-
Your
I
Honor,
see.
perhaps he's on the wrong link.
You know what,
Okay,
ask him if he has it, ask him for his phone number. I'll just call him from the courtroom. I can get him over the phone.
Okay, I'll give you his phone number right now.
Okay, what is it?
The phone number. That's strange. I'm on the line. Okay.
Your Honor, if I may,
Yes, ma'am.
for Mr. Block's case, I assume it's a complex track. We just need a track to be assigned.
Oh, okay. Well, it was on for this morning on this complex docket, so I thought that it was actually already on the complex track. Would everyone agree that Mr. Block's case is complex and it should remain on this track?
Your Honor, I believe Mr. Tompkins has dropped off, but I don't think, we're fine leaving it on this particular docket, Your Honor, on this track.
All right, let's just leave it for now, and then if Mr. Tompkins wants something different, he can address it with Judge Manuelich on the next docket if necessary.
Thank you.
Okay, thank you.
Here's Mr. Kaji's number, 239-216-2701.
Okay. 2701. All right, let me see if I can get him on the phone. Oops, I'll move this a little bit. Oh no, I dialed the wrong number.
Hello, you have reached Genova. For sale,
Okay. 216-2701?
Yes.
Let me try it again. Maybe I dialed the wrong number. Good morning. Hi, is this Mr. Kaji? Hi, Mr. Kaji. This is Judge Nicola. I'm standing in for Judge Manulich today. How are you? Good. I understand you had a little bit of difficulty with the Zoom, so I figured we'd just call you from the bench. I have your attorney over the computer, and it's next to the phone. So we wanted to discuss your case a little bit this morning. And again, for the record, we're back on the record on Kent Kaji, 20 CF 1067. I have the state present and his attorney, Mr. Youngblood, also present. And Mr. Kaji, this morning, before we got you on the line, we were talking about a couple of things. One is that it appears that you have two different law firms representing you, Mr. Youngblood's law firm and also the Muska law firm. Is it your desire to have both firms continue to represent you, sir? Okay. And then we discussed who the state attorney's office should primarily communicate with. And Mr. Youngblood indicated that he would like that they primarily communicate with him. Would that also be your desire, sir? Okay, because, you know, the state may have some things that they want to provide to your counsel and also may want to have conversations with counsel. And it's nice to have one person who is the primary so that we can make sure information is shared equally with everyone, okay? All right, so with Mr. Kaji's case now, how do we wish to proceed with his case?
Waive speedy trial, move to continue, request that May date.
What say the state on the May date?
Objection.
All right, so Mr. Kaji, your case is going to be continued until the case management conference, which will be scheduled on May the 7th. Keep in touch with your attorneys and they'll be able to advise you further with respect to how your case is proceeding, okay?
Your Honor, is that 9 a.m.?
Yes, ma'am, it's 9 a.m.
Thank you.
All right, thank you, Mr. Kaji. All right, bye-bye. And that is everybody on the 9 o'clock docket.
Thank you, Your Honor. I think that's all I have. May I be excused?
Yes, you may. And if you would please, Mr. Youngblood, if you could get in touch with the Muska firm and just let them know that they need to, you know, figure out how to fix the fact that Mr. Roystacker's gone. We got to have counsel of record on everybody's cases. So.
Yes, ma'am, I will.
All right, thank you. Have a good weekend.
Your Honor.
Yes, ma'am.
I'm covering for Mr. Frazier, and I was told that he has 2 additional cases on the docket.
On the 9 o'clock?
Yes.
Oh, I took care of all the 9 o'clock. I think they're all gone.
I have a Gabriel Garza and a Fedner Alzim.
I don't have Mr. Garza or Mr. Alzim on the 9 o'clock docket, neither one. I have Allen, Bachios, Block, Bolio, Kaji, and Tennessee. And there's no other cases other than those.
Okay. All right,
So I don't
thank you.
have them put on, but they're not there.
Okay, thank you.
All right, thanks, Ms. Rumley. All right, so that brings us to our 9:30. If we're ready to proceed, we're a few minutes early. Everybody ready to go? I'm not hearing any objections to starting early, so we'll start early. It looks like, Mr. Khalil, your case is first. Merlin Bowers, would you like to start with him, sir? Yes. 20 CF 1478. Mr. Bowers, good morning. Oh, she is. Is Ms. Mason on this case and is she coming down? Okay. Well, we'll just, it's just going to take just a minute. Do we have another one that's ready to go with the state attorney and a defense attorney present that wants to take the plea first?
Your Honor, I believe we have a brief continuance on Mr. Cluck's matter.
Okay, let's do the continuance first. What is the name of the defendant, please? Oh,
Trent Cluck, 19 CF 1664.
Hold on one second, sir. Are you Mr. Cluck? Okay, your attorney's over Zoom and is asking to continue this matter. Is that correct, Mr. Barger?
Yes, Your Honor, that is.
And where do you want to put this case, sir?
We would ask to put this to the February 24th VOP sounding docket at 9 a.m.
So your case is going to be put on the violation of probation sounding docket at 9 a.m. on February the 24th. Was that the date, sir?
Yes.
February the 24th. Okay, thank you, Mr. Cluck. All right, so that'll take care of that.
Thank you, Your Honor.
Thank you, sir. Mr. Day, you said your case is ready. Is that Mr. Corey Williams, 20 CF 1299? No? Okay. All right, and this is case number 20CF1299, Corey Williams. And are we going to be scheduling? I don't have Ms. Fuentes anymore over Zoom, but when we last spoke yesterday, the next pretrial was going to be June the 8th, with another June 22nd date at 9 and a June 28th at 9. One was it was 6/8 for the pretrial, and then the next date was 6/22 and then 6/28. I don't. Okay, so we'll set it there. That's what she was doing yesterday when the case manager was over Zoom. She was setting all 3 dates, saying 6/8 was the pretrial. I haven't written down all of them. There we go. That's it. Thank you. Okay, so that one's gone. And anybody else ready to go that's got a state attorney and a defense attorney? Mr. Nagel? Okay, we're ready for you, Mr. Nagel. And thank you. And this is 19CF1762, Mr. Morales Barcinas, excuse me. Okay. And upon completion of all conditions, I assume? Yes, of course. Of course. Okay. Does the abuse evaluation follow all recommendations? That there's a protest. The use of specific case. 298? 298, sorry. And that's on the possession of controlled substance. What about there's 2 counts of possession of controlled substance. Okay. Concurrent. All right. Okay. Thank you. Okay, then that is done. Today's the 21st? 22nd, that's right. Thank you. Yeah. All right. Yes, ma'am. Thank you. The court will take judicial notice of 19 CF 1762, and the court has also reviewed the file and the information contained within the file. Does find that there is a factual basis and venue. Also, will accept your plea, find that it is freely, voluntarily, knowingly, and intelligently made. To the 2 counts of possession of drug paraphernalia, the court will withhold adjudication of guilt, sentence you to 12 months of supervised probation, which may terminate early after 6 months and after completion of all conditions, which will be concurrent. You will have a substance abuse evaluation, follow all recommendations, random urinalysis upon request and at your own expense. You will owe the cost of investigation in the amount of $298 payable to the Collier County Sheriff's Department. Also, you will be responsible for the cost of this action, the cost of prosecution, and all applicable public defender fees. Thank you. And let's see, the public defender fee. I see a public defender fee of $100 plus a $50 application fee. And looks good. Also, sir, you'll be fingerprinted today, and they will also take a DNA swab, and your right to appeal starts today, 30 days to appeal. Thank you. Thank you, sir. Okay. Who do I have over Zoom this morning? Okay. I just want to make sure I'm not doing any pleas over Zoom, right? I still have 3 people over Zoom. Anybody? I have 2 people.
Shelley Marks.
Yes, ma'am. Who are you and what case are you here for today, ma'am?
My name is Shelley Marks. I don't know my case number though.
Okay, Ms. Marks. Are we doing a plea for Ms. Marks, Mr. Khalil? All right, hold on, Ms. Marks. We're going to address your case in just 1 minute. The state attorney has stepped out. I have 2 people
thank you.
over Zoom. One says 239-246-0902, and actually, you're on there twice somehow. Who's 246-0902, please?
That's me.
What's your name, ma'am?
Shelley Marks.
Oh, okay. Ms. Marks, for some reason, you're over Zoom 3 times on your iPhone, and then I'm showing two phone numbers. So we'll be with you in just a minute as soon as we have our state attorney back in the courtroom.
Okay, thank you.
Okay, so we're ready for another one? Mr. Robbins, Ms. Roger, and that's 19 CF 2248. That would be fantastic. Okay. Wonderful.
There's a $3,570 amount restitution that will be up front. $100 cost after the $3,570 paid up front, there will be a leftover restitution of now.
$3,500, I thought you said restitution.
$3,570 up front.
Oh, $3,570. And who's that payable to? Confidential? Okay. All right. Okay. Okay. All right, let me just reiterate what I've got here and make sure that I'm right. It's going to be an adjudication of guilt on all 5 counts, 3-year state probation, random testing for drugs and alcohol, substance abuse evaluation within 30 days, follow all recommendation, no contact with the victim, no trespass, it's both going to be confidential. Special condition of probation will be enroll in complete Justin's Place, follow all recommendations of aftercare from Justin's Place, 3570 in restitution, confidential, 2868 cost of investigation to CCSO. The 3570 is going to go to all counts except for count 1. $10,041.61 restitution at $100 a month for count 1 after release from Justin's Place. Cost of prosecution of $100. Will run concurrently with 19 CF 586 in the county. There was something else I think I missed. Did I get it all? Oh yeah, due immediately. Okay. Okay.
I think they have to set have the money ready to go. Again, it's really great, but
Why don't we give them a week? I mean, 7 days? That makes sense. I mean, that's pretty quick. All right. I mean, it sounds like it's just semantics. Okay. Okay. All right, sounds good. Thank you. All right, so count 1 is grand theft. Count 2 is providing false information upon items. 4 is the same, the false info. And let's see here. 7 is the same, or no, it's 17. I'll really scroll down, find 17. Dealing stolen property. And then the other one was 18, which is also dealing in stolen property. So one count of grand theft, 2 counts of giving false information, and 2 counts of dealing in stolen, right? Got it. All right, we're ready. Yes, 3570. Yes, ma'am. Okay, ready. Go ahead.
Swear or affirm that the testimony that you give shall be the whole truth and
You may. Thank you.
And then this way you're getting on the right to my bird class. You can get on the right at the blue. The right to speak, hear the state. Right to testify.
Okay. Thank you. Okay, so the court will take judicial notice of case number 19 CF 2248, and the court has reviewed the file and the information contained therein. Does find that there is a factual basis and venue. I will accept your plea, find that it is freely, voluntarily, knowingly, and intelligently made. To the charges, count 1, which is grand theft, count 2, which is providing false verification of ownership to a pawnbroker, count 4, which is also providing false verification of ownership to a pawnbroker, count 17, dealing in stolen property, and count 18, dealing in stolen property. The court will adjudicate you guilty, sentence you to 3 years of state probation, You will be subjected to random drug testing and alcohol testing upon request and at your own expense. Substance abuse evaluation within 30 days. Follow all reasonable recommendations. There will be no contact with the victim, no trespass. Also, both will be confidential. Special condition of your probation will be that you will enroll and complete the Justin's Place program and also follow all recommendations for aftercare. You will pay $3,570 in restitution to the confidential victim. That will be as to all counts except for count 1. That will be due and payable within 7 days from today. $2,868 in investigatory costs to the Collier County Sheriff's Department. $10,041.61 payable in restitution at a minimum of $100 per month. As to count 1, that amount will begin to be paid as soon as you are released from Justin's Place. It will also be concurrent with the Lee County case number 19 CF 586. There also will be a $100 cost of prosecution. I think that's everything, right? Yes? All right, thank you. Thank you, everyone. And why don't we address the lady that I have over Zoom? And what was your name again, ma'am?
Miss Shelley Marks.
Miss Marks. And this is 19 CF 1552. I understand you're asking to continue this, Mr. Khalil? What's the state on this? My preference would be that if it's going to be a resolution, that it not be on a trial docket, that it go to a case management. But what's the state's position on that, please? Right. All right, let me see, what are those dates? Let me see, where's my, okay. Let's set it there. That way we'll have a pretty good idea what's going to happen with this case by then. All right. Thank you, Ms. Marks. We're setting you on that February date and get in touch with your attorney and try and see if you guys can get it all worked out, okay? Thank you.
Okay, thank you. Do you know what the date is?
It was supposed to be February what? 25th. February 25th, ma'am. Okay?
Okay. Do I call or do I come in?
Everything is still being done remotely, but just be in touch with Mr. Khalil. He can tell you whether you'll need to appear for that. Okay. Thank you for coming in today over Zoom.
All right. Thank you.
Thank you. All right. Let's see. Sign. I don't think I've signed a piece of paper in a very long time because I do everything. Everything has been like. Oh, okay. I guess we need to address that. Okay. All the rest. Okay. Who's over the iPhone on Zoom? Is that still you, Miss Marks? All right. I think that's Miss Marks. Who's over the iPhone on Zoom? Nobody. Okay, they're gone. All right, Miss Mason. All right. I don't. Okay.
The terms of this agreement are adjudication, 2 years state probation. Your Honor, he is a California resident, and therefore this place, so if we could just please no objection to transfer back.
Okay. All right.
He will be subject to random drug and alcohol testing at some expense. He's receiving substance abuse evaluation within 30 days of all the recommendations. No trespass for 1046 Pine Ridge Road, Florida. That's Nicola, therein address. And possession and consumption of alcohol during the period of the he does work in hospitality industry, so I would ask if you can apply any section for that purpose. And there will be a letter of apology to the USO deputy. I wrote those dates. I'm reading confidential.
Okay.
This in terms of cost, your honor, is $100 cost prosecution, court costs, and $406 investigation costs being payable to CCSF. And all terms are for yeah.
Okay. Sure. All right, we're ready.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Okay. Thank you. Yes, ma'am.
Would you say your full name and date of birth, please?
Marcus Richard Michael Loss. Birth is January 29th, 1993.
And what are the last four digits of your social security number?
9047.
Have you ever been known by an alias or any other name?
Yeah.
Where were you born?
Long Beach, California.
And how far did you go to school?
I have a bachelor's, but I left school at 15 weeks ago to go to an apprenticeship. So it was kind of long. Yes.
Okay, are you able to read, write, and understand the English language?
Yes.
Are you under the influence of any drugs or alcohol today?
No.
Are you prescribed any medication?
No.
Have you ever been diagnosed with a mental condition or disorder?
It's ADHD and dyslexic.
Thanks really quick. And so, do you feel that as we said here today, do you feel that you are suffering from either of those conditions at this time?
My ADHD is always there.
Does that ADHD, does it impact your ability to understand what's going on today?
Not at all.
Does it impact your ability to make decisions about your case?
Right.
And as we said here today, do you feel comfortable that you're in a position to make those decisions about your case today? Do you understand why we're doing it? In case number 20 CF408, you're charged with count 1 battery on a law enforcement officer, a 3rd-degree felony, punishable by up to 5 years in state prison. And count 2, resisting an officer with violence, a 3rd-degree felony, punishable by up to 5 years in state prison. To each of those counts, are you pleading guilty, not guilty, or no contest?
No contest.
Do you understand that battery is an enhanceable offense, which means that if you are convicted of it in the future, that future charges could also result in additional felonies, longer jail time, higher fines? Do you understand that?
Yeah.
Okay. Do you understand that by entering your plea today, you're waiving your right to the jury trial? And that at that trial, you would have the right to seek and hear the state's witnesses testify and have a lawyer question them, the right to subpoena your own witnesses and submit evidence on your behalf, the right to testify or to remain silent, and the right to make the state prove these charges beyond a reasonable doubt. Do you understand your waiving those rights? Mr. Roger, have you ever served any hours for appeal? No. Mr. West, do you understand that you're waiving your right to appeal anything other than whether this court has the jurisdiction to impose this sentence? Have you had the opportunity to review a plea form?
Yes.
Okay, so showing the plea form here, it's front and back. It has your name here at the top with the case number. And on the back, there are 2 signatures. Are those 2 signatures? Does one of those signatures indicate that you've read this form or that it's been explained to you, you understand all the rights contained in it? Have you had the opportunity to discuss this plea form with your attorney?
Yes.
Do you have any questions about it?
No.
Have you had the opportunity to review your score sheet?
Yes, I agree.
Mr. West, you've now had the opportunity to review your score sheet with your attorney? And your score sheet shows a total of 35.6 sentencing points. The maximum sentence you could receive, if each of the maximums for each charge was to run consecutively, is 10 years in state prison. You understand that? And you agree that this score sheet is accurate?
Yeah.
And for the record, that this score sheet shows you have no prior criminal convictions. Other than what's been placed on the record and what's contained in the plea form, has anyone promised you to get anything to enter this plea today? Are you entering this plea in your own free will? Are you entering this plea because you feel that doing so is in your best interest? Are you being forced or threatened by anyone? Are you satisfied with the advice and counsel of your attorney? Has she done everything you've asked and answered all of your questions? Has she discussed this case with you in its entirety, including any possible offenses that you may or may not have? Counsel, you reviewed all the discovery in this case with the client in the world? Mr. Wentz, is there anything about your case that you wanted a chance to review that you haven't had a chance to review?
That's more or less just say sorry. I didn't get a proper chance during the statement to actually apologize for what I did.
Thank you for that, Mr. Wentz. Your Honor, I'm not aware of any physical evidence to be tested for DNA that could potentially exonerate the defendant. Counsel, do you agree? I agree. Mr. Wentz, do you understand as a result of your plea today, there is no physical evidence in this case that will be tested for DNA? Do you understand that if you're not a United States citizen, you may be subject to deportation or removal as a result of this plea? And that immigration proceedings are separate proceedings outside the jurisdiction of this court, and no one can promise you what would happen in those proceedings.
I'm a dual citizen. How does that work when it comes to international traveling and having citizenship in New Zealand?
Well, that actually may be something that you may want to discuss that with an attorney, whether it's with the driver or with the immigration attorney.
All different stuff after this.
They're separate proceedings, and we couldn't tell you in this court what would happen in that case. Would you like some additional time to discuss this with an attorney?
No, I'll figure that out. It's all new. But yeah, I'll figure it out.
Okay. And do you understand that if you were later deported or removed from the United States as a result of this plea, it would not be a basis to come back and withdraw your plea? Do you understand that? Counsel, do you stipulate that the court may allow the court filing affidavits contained therein to establish a factual basis and venue? I do. And that venue is proper in Clark County, Florida? Yes. Your Honor, you also waive PSI? Yes. Your Honor, at this time, the state will ask the court to make sure this is the court filed in case number 20 CF 408, which entered the plea of the court. I'm handing forward the plea form, the score sheet, and also prepared an order of no trespass, which was rather reviewed.
Thank you. And Mr. Watts, do you understand that you may find out later that being convicted of a felony may actually affect your ability to travel freely without the United States? And knowing that, would that make you change your mind about entering this plea? Okay, I'm just making sure, because that would not be basis for setting aside the plea before the court if you found out that you would not be able to travel as a result of being convicted of a felony. Understand? Okay, just making sure. All right. So the court will take judicial notice of case number 19 CF 408, find that there is a factual basis and venue. I will accept your plea. I'll find that it is freely, voluntarily, knowingly, and intelligently made. Oh, I said 19. I said it. I wrote down 19. I don't know why. I'm so sorry. I actually wrote it down wrong. I'm sorry. It's 20 CF 408. To the charge of battery on a law enforcement officer, resisting arrest with violence, and loitering or prowling. Oh, thank you. I had 3 on my dashboard, so I apologize. To battery on a law enforcement officer, resisting arrest with violence, the court will adjudicate you guilty, sentence you to 2 years of state probation. No objection to you transferring it to California. Restitution will be ordered. I'm sorry. And I wrote down rest, and you know what rest meant? Res. Random urinalysis or breathalyzer upon request and at your own expense. Substance abuse evaluation within 30 days. Follow all reasonable recommendations. There will be a no trespass at Pelican Larry's, which is located at 1046 Pine Ridge Road, Naples, Florida. There will be no alcohol during the term of your probation. No alcohol in your residence, no visiting any bars, taverns, pubs, lounge, package stores, or places where alcohol is primarily served or sold. Special exception is that you may serve alcohol for work purposes. You will write a letter of apology to the Collier County Sheriff's Office deputy, who will remain confidential. $100 cost of prosecution, court costs, $406 of cost of investigation payable to the Collier County Sheriff's Department. All terms will be concurrent. Was there a victim in this? Was there no contact on that?
No, Your Honor, the victim is old.
Okay. And I think that's everything, right? Yes, ma'am. We just got to just put in letter apology / confidential. Got it. I see that. Perfect. Thank you, Lisa. Good. All right. Good luck to you, sir. The court does appreciate your you putting on the record your apology. Sometimes a good thing comes out of a bad thing. It does happen. It's unfortunate that it took a serious incident like that for it to happen, but the good thing is that it sounds like you've learned from it. So it could have, for sure. So thank you. Thank you. I think my pen just died. Seriously? It's dead. Do you have an extra one by chance over there? Because otherwise I have pencil. We can't sign court orders in pencil. Thank you. It's the bad thing about those pens. They really run out of ink really quick. It's so messy. Uh-oh, what just happened here? Oh, there's that. Okay. I need to get these standing desks in the courtroom. That would be really awesome. I'm gonna put that on the list. All right. Thank you, Ms. Roger. All right. Who's next?
Your Honor, we called Ricardo Martinez, 19 CF 1398 and 19 CF 1306.
Okay, Mr. Martinez, good morning.
Good morning, Judge.
Good morning, sir.
Regular story on behalf of Mr. Martinez. Judge, earlier in the week, we believe that we're all set to go forward with the plea. I got a message from Mr. Martinez this morning where he had some additional questions for me. So I don't think we are ready to go forward with the plea this morning.
Okay.
I do just want to let Mr. Martinez know that I had further discussions with the state, and at this time, they are not willing to change the current offer. They are willing to discuss the matter with me further, but they want Mr. Martinez to know that if he doesn't want to take the offer today, they will not promise that that offer will remain open if we continue the case.
All right, Mr. Martinez, we are here today in two cases, one of which is 19 CF 1406 and 19 CF 1398. Were you able to hear your attorney's comments, sir?
Yes.
Do you have any questions? Do you understand? I understand that there was a plea offer that was conveyed to you that initially you were considering And we were here today for you to accept that plea, but you have some additional questions. Is that right?
Yes, ma'am.
Okay. Do you also understand that the plea offer that's currently being provided to you may no longer be available to you should you decide to change your mind after today? In other words, it could get better, but it also could get worse. Do you understand that?
Yes, ma'am.
And you still do not want to move forward with the plea today, is that correct? All right. So where would we like to set this case then? Since it's not going to be a plea, we need to probably set it on a case management, correct? Or do we want to set it on a trial?
No, Judge, because we are close. I heard you mention that February 25th date. Can I have that?
I think so.
Your Honor, he has no objection to whatever date is concerned.
How's February 25th, Lisa? Is that what the...
February 25th, they want to carry all the dates that I call. So,
Yeah, I'm sure they are. I think all of us judges right now just have these monster dockets.
Oh, I know.
It's just, yeah. It's funny because Judge Minor said to me, Judge Nicola, you're going to be shocked by how big my dockets are. And I said, well, mine are the same, sir. So.
Well, I already have my report, Judge Minor at that date and time, so it'd be perfect.
Okay, let's just set it then. Both your cases are going to be set on the 25th of February, sir, at 1:30. And then we'll see what we can do between now and then. Okay, thank you. Thank you, sir.
Thank you, Judge.
All right.
Thank you, Steve.
So it looks like we've got 4 left. Which one do we want to take?
Hernandez, case number 20 CF 948.
Okay. Mr. Hernandez, 20 CF 948. And Mr.
Exactly what on behalf of Mr. Hernandez. Mr. Hernandez is prepared to resolve this case with a no contest plea as charged. In terms of the plea agreement, the adjudication of guilt, 270 days in private town jail, credit of 199 days served. Court costs will be $767, $100 cost of prosecution. Public defender fees in this case will be $149 plus the $15 application fee. And will be $301 cost of restitution for the party punishment.
How much was that? 300 and what?
And what?
301? Thank you.
301, it's cost of restitution. Okay, so it's not restitution. I'm sorry.
Oh, I wrote down restitution too, and it should be investigation. Okay. All right.
Raise your right hand and be sworn.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
And sir, we do need to have you speak up just a little bit because we can barely hear you, okay?
Yes, ma'am.
Oh, thank you. All right, we're ready.
Would you state your full name and date of birth?
Hernandez, 6/13/89.
And what are the last 4 digits of your social security number?
1685.
Have you ever been known by an alias or any other name?
No.
Where were you born?
Ohio.
And how far did you go in school?
10th grade.
Are you able to read, write, and understand the English language?
Yes.
Are you under the influence of any drugs or alcohol today?
No.
Are you prescribed any medications?
Yes.
And is that the medication that you take? Is it a medication that you would typically take in the morning?
Yes.
Have you taken that medication today as prescribed?
Yes.
And does the fact that you've taken that medication, does it impact your ability to understand what's going on today?
No.
Does it impact your ability to make decisions? And as we stand here today, do you feel that you're thinking clearly and able to make a decision about your case?
Yes, ma'am.
Mr. Hernandez, have you ever been diagnosed with a mental condition or disorder?
No.
Do you understand why we're here today?
Yes.
Mr. Hernandez, you're currently appearing in court through audiovisual means. Do you have any objection to not being physically present in the courtroom and resolving your case this way?
No.
In case number 20 CF 948, you're charged with 1 count of battery on a law enforcement officer. That's a third-degree felony, and it's going to go up to 5 years in state prison. To that charge, you plead guilty, not guilty, or no contest?
No contest.
Do you understand, Mr. Hernandez, that battery is an enhanceable offense? It means that if you are charged with battery again in the future, you could receive higher fines, longer periods of incarceration, and you could also be charged with a felony. Do you understand that?
No.
Do you understand that by entering your plea today, you're waiving your right to a jury trial?
Say that again?
By entering your plea today, you're waiving your right to have a jury trial in this case. Do you understand that?
Yeah.
And at that trial, you would have had the right to see and hear the state's witnesses testify and to have your lawyer question them. The right to subpoena your own witnesses and submit evidence on your behalf.
I just heard you say no. What was the no to, sir? You don't know? Are you listening?
Yeah.
It's really important that you understand what you're doing here today, because if you don't understand what you're doing here today, or you say an answer no to something, the court cannot accept your plea. So it is not funny. It's very serious. So, okay, thank you.
Well, Mr. Hernandez, if this case had gone to trial, there are some very important rights that you would have had. And I want to make sure that you understand those rights. You would have had the right to see and hear the state's witnesses testify against you and have your lawyer question them. You would have had the right to subpoena your own witnesses and submit evidence in your own behalf, the right to testify or to remain silent, the right to make the state prove this charge beyond a reasonable doubt, and the right to have a jury determine whether you were guilty or innocent of this charge. Do you understand that by entering your plea today, there is not going to be a jury trial, so you are waiving all of those rights?
Yes, ma'am.
Counsel, have you reserved any matters for review? Mr. Hernandez, have you had the opportunity to review and sign a plea form there?
Yes.
Did you get have you reviewed that form with your attorney?
No.
Do you have any questions about that plea form?
No.
Did you understand it?
Yes.
And does one of the signatures that you put on that plea form, does it indicate that you've read that form or that it's been explained to you and that you understand all the rights contained in it?
Yeah.
Have you had the chance to review your score sheet?
Yes, ma'am.
And your score sheet shows a total of 27.6 sentencing points. The maximum sentence that you can receive on this charge is 5 years in state prison. Do you agree that the score sheet is accurate?
Yes, ma'am.
Other than what's contained in the plea form that you read, and what's already been placed on the record, has anyone promised you anything to get you to enter this plea today?
Yes, he promised 9 months.
Okay, so other than the actual plea agreement itself, the 9 months in jail, has anyone promised you anything else to get you to enter this plea?
No.
Are you entering this plea on your own free will?
Yes, ma'am.
Do you feel that entering this plea is in your best interest?
Yes, ma'am.
Are you being forced or threatened by anyone to get you to enter this plea?
No, ma'am.
Are you satisfied with the advice and counsel of your attorney?
Yes, ma'am.
And has your attorney done everything you've asked and answered all of your questions?
Yes, ma'am.
Has he discussed this case with you in its entirety, including any possible offenses that you may or may not have?
Yes, ma'am.
And counsel, have you reviewed all the discovery in this case with your client? Mr. Hernandez, is there anything about your case that you wanted a chance to review, but you have not had an opportunity to review?
No, ma'am.
Your Honor, I want to learn any physical evidence can be tested for DNA to potentially exonerate the defendant. Counsel, do you agree? Mr. Hernandez, you understand as a result of your plea, there is no physical evidence in this case that would be tested for your DNA?
Yes.
You understand that if you were not a United States citizen, you may be subject to deportation or removal as a result of this plea.
Yes, ma'am.
And that immigration proceedings are separate proceedings outside the jurisdiction of this court. No one could promise you what would happen in those proceedings. Do you understand that?
Ma'am.
And that if you were deported or removed as a result of this plea, it would not be a basis to come back and withdraw your plea. Do you understand that?
Yes, ma'am.
If the offense to which you are pleading is a sexually violent offense or a sexually motivated offense, or if you have previously been convicted of such an offense, this plea may subject you to involuntary civil commitment as a sexually violent predator upon completion of your sentence. Do you understand that warning?
Yes, ma'am.
Counsel, do you stipulate that the court may rely on the court filing affidavits contained therein to establish a factual basis of venue? And that venue lies in Clarence County, Florida? Your Honor, at this time, the state would ask the court to take judicial notice of the court filing case number 20 CF 948 with tentative legal court, and I'm moving for these.
Thank you. Thank you. Okay, so the court will take judicial notice of case number 20 CF 948, and the court has reviewed the information in the court file. Does find that there is a factual basis and venue. Will accept your plea, find that it is freely, voluntarily, knowingly, and intelligently made to the charge of battery on a law enforcement officer. The court will adjudicate you guilty, sentence you to 270 days in the Collier County Jail, credit for all time served, which I understand is 199 days. Court costs and the cost of prosecution, all applicable public defender fees, $301 in cost of investigation payable to the Collier County Sheriff's Department. Thank you. Thank you, sir. Yes, ma'am. Oh, yes, and sir, you do have 30 days to appeal. You guys have to remind me to say that. For whatever reason, we don't put that on the record in the misdemeanor case, but I did have that in my notes, so thank you.
Northern Hours, 20 CF 1478. This is with that.
It's good, Lisa. Thank you. All right. There you go. Thank you. All right, Mr. Bowers, just give me 1 minute. And this is case number 20 CF 1478. All right, we're ready.
Yeah, he'd like to withdraw his previous plea of not guilty and enter into a plea of no contest. The offer on both counts is an adjudication, 24 months of probation, substance abuse evaluation, all recommendations, random testing, no alcohol, 6 months of driver's license revocation, court cost of prosecution, public defender fees, and also investigation of $452.
Okay, it's adjudication. What was the amount of probation, did you say? I'm sorry?
24 months.
24 months, okay. And how many counts is he pleading to?
Both counts.
Just 2? Okay. Is it 1 and 2, which is controlled substance, and then 2 is also controlled substance?
Yes, sir.
Okay, thank you. All right, we need to get him sworn in.
Raise your right hand.
Is the investigation cost to the sheriff's office?
Yes, $452 to the Collier County Sheriff's Office.
Okay. Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Would you state your full name and date of birth?
Ronald Bellis, 2/21/1964.
And what are the last 4 digits of your social security number?
874.
Have you ever been known by an alias or any other name?
No.
Where were you born?
St.
I'm sorry?
Louis.
St. Louis, Missouri, is that what you said?
Yes, ma'am.
Thank you.
Thank you. And how far did you go in school?
High school, 2 years, kindergarten, vocation school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you under the influence of any drugs or alcohol today? Are you prescribed any medication?
On the outside, you take gabapentin and 2 other medications. The pain medications.
Pain medications? Okay. And are those pain medications, are those medications that you would have taken today in the morning? And did you take those medications this morning as prescribed?
Well, they only give you ibuprofen here, so that's ibuprofen, yes.
I don't think ibuprofen's prescribed.
Okay. So just ibuprofen. Okay.
No.
Are you suffering from any kind of mental condition or disorder?
No.
Do you understand why we're here today, Mr. Bowers?
Yes, I do.
And you're currently appearing remotely through audiovisual means. Do you have any objection to not being physically present in the courtroom and resolving your case this way?
I have no objection.
Mr. Bowers, in case number 20 CF 1478, you're charged with 2 counts of possession of a controlled substance. Each of those counts is a third-degree felony, and each is punishable by up to 5 years in state prison. To each of those counts, are you pleading guilty, not guilty, or no contest?
No contest.
Do you understand that as a result of the adjudication on each of these counts, that your driver's license will be suspended for a period of 6 months?
Yes, ma'am.
And that driver's license revocation will begin upon your release from custody. Do you understand that?
Yes, ma'am.
Do you understand by entering your plea today that you're waiving your right to a jury trial?
Yes.
And at that trial, you would have had the right to see and hear the state's witnesses testify, to have your lawyer question them, the right to subpoena your own witnesses and submit evidence on your behalf, the right to testify or to remain silent, the right to make the state prove these charges beyond a reasonable doubt, and the right to have a jury determine whether you were guilty or innocent. You understand that you're waiving those rights?
Yes, I do, ma'am.
And counsel, have you reserved any matters for appeal?
No.
Mr. Bowers, do you understand that you're waiving your right to appeal anything other than whether this court has the jurisdiction to impose this sentence?
Yes, I do understand that.
All right, and have you had the chance to review your score sheet with your attorney?
Yes, I have.
All right, and your score sheet shows a total of 30.2 sentencing points. The maximum sentence you could receive if each of the maximums on each count was to run consecutively is 10 years in state prison. Do you understand that?
I do.
Do you understand the offer in this case is that you're being placed on 2 years of probation. Your probation has certain conditions that the probation officer will go over with you. If you were to violate the terms of your probation, do you understand that the court could then, that you could still face up to 10 years in state prison?
Yeah.
Do you agree, and having reviewed your score sheet, do you agree that your score sheet is accurate?
Yeah.
Have you had the chance to review and sign a plea form?
Yeah.
Did you go over that plea form with your attorney?
Yes.
Do you have any questions about it?
No.
And does one of your signatures on that form indicate that you've read that form or that it's been explained to you and you understand all the rights contained in it?
Yes.
Other than what's been placed in that plea form and what's already been placed on the record, has anyone promised you anything to get you to enter this plea today?
No.
Are you entering this plea in your own free will?
Yes, I am.
Do you feel that entering this plea is in your best interest?
Yes, I do.
Are you being forced or threatened by anyone?
Nope.
Are you satisfied with the advice and counsel of your attorney?
Yes.
Has he done everything you've asked and answered all of your questions?
Yes.
Has he discussed this case with you in its entirety, including any possible offenses that you may or may not have?
Yeah.
Counsel, have you reviewed all the discovery in this case with your client?
Yes.
Mr. Bowers, is there anything about your case that you wanted a chance to review that you haven't had the opportunity to review? I'm not aware of any physical evidence can be tested for DNA to potentially exonerate the defendant. Counsel, do you agree?
I agree.
Mr. Bowers, do you understand that there is no physical evidence in this case that would be tested for your DNA?
Yeah.
Do you understand if you're not a United States citizen, you may be subject to deportation or removal as a result of this plea?
Yes, I understand.
And that immigration proceedings are separate proceedings outside the jurisdiction of this court. No one can promise you what will happen in those proceedings. Do you understand that?
Yes.
And Mr. Bowers, if you happen to be deported or removed as a result of this plea, it would not be a basis to go back and withdraw your plea. Do you understand?
Yes.
Counsel, do you stick with the court and rely on the court file and the affidavits contained therein to establish a factual basis of venue?
I do.
And that venue is proper in Collier County, Florida?
Yes.
Your Honor, at this time, the state would ask the court to take additional notes of the court file in case number 20 CF 1578 and would tender the plea report many forward these questions.
Thank you. Okay, so the court does take judicial notice of the court file in case number 20 CF 1478. Does find that there is a factual basis and venue in Collier County. The court will accept your plea, will find that it was freely, voluntarily, knowingly, and intelligently made. To both counts of possession of a controlled substance, the court will adjudicate you guilty, sentence you to 24 months of probation, state probation, correct?
Yes, sir.
You will have a substance abuse evaluation, follow all recommendations. There will be a random breathalyzer or your analysis upon request and at your own expense. No alcohol during the terms of your probation, no alcohol in your residence, no visiting any bars, taverns, saloons, pubs, lounges, package stores, or places where alcohol is primarily served or sold. 6 months driver's license suspension, may obtain a work permit if you qualify. That's not up to me, that's up to the DMV. Court costs, cost of prosecution, and costs, public defender fees, $452 cost of investigation, which will be payable to the Collier County Sheriff's Department. Thank you. Yes, sir.
Another thing that I did not hear that I spoke with my attorney about was early termination at the halfway point if I complete everything.
You can always make application for early termination. The court is not going to make a finding that your probation will terminate early upon successful completion, but you always may apply to the court with the assistance of your attorney and ask the court to terminate it early. You will either have a hearing on that, or sometimes the council will stipulate to it, and it makes it easy for the court. But of course, you can always ask, and we do, at least I do, and I think Judge Meinelich does as well, encourage people to complete the terms of their probation because it's good for everybody. So yes, you can always make application to do that, sir. Okay. All right. Thank you. Yes, you have 30 days to appeal, sir.
And also your, it's a little less than 10:30, Mr. Bauer, should be released from custody today. We would ask that he report to probation today. However, if he released after about 5:30 report within within 24 business days.
So, sir, if you're released from probation today, you will need to report today. But if you are not released until after 5 o'clock today or close to 5 o'clock so that it's impossible for you to get there, we would ask that you please report first thing Monday morning, okay? Thank you, sir. All right. Thank you. All right, let's see what we got here. Yes, let me just make sure I got everything on here. Oh, looks good. Thanks, Lisa. Did I sign this? No, I did not. Mr. Wise, Mr. Wise is here. Yes. Sure. What you got? Okay.
My documents were listed why it's just case number 20, you have to give me a second, 'cause I don't have that in my document.
Let me find it. It's on my docket. Joseph Wise, 20 CF 1357. You don't see that, Lisa? I see left on my docket Mr. Pena and Mr. Wise. Oh, it's showing up on Smart Bench. That's what I use, so it's there. But gives me a stand break. I'm not used to all the sitting. That was one of the things I had to get really used to becoming a judge, is sitting all day long. So I just stand. Is that everybody in the jail today, or do we have one more? Is Mr. Pena in custody? He is? Okay.
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 Yes. 1357, my document is with Mr. Wise. Madam Clerk, Your Honor, the proposed resolution will be a plea as charged to count one, murdering a law enforcement officer, third degree felony. The proposed resolution as to that count will be an adjudication of guilt. 36 months state probation. Mr. Wise understands he would have to report immediately after leaving court today.
Okay.
There will be an anger management course completion, 75 hours of community service. There will also be a letter of apology. I'm not going to state the officer's name on the record, but there will be a letter of apology to the officer. $100 prosecution costs, court costs, and $209 investigative costs to the Collier County Sheriff's Office. Should the court accept the plea, count 2, resisting an officer with violence, will be authorized by the state.
That is correct. Okay, let's get him sworn in. I know.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
All right, thank you. You can proceed.
Thank you, Your Honor.
Thank you.
Sir, would you please state your full name for the record?
Joseph Robert Wise,
And what is your date of birth?
last name is 83,
And last name
3417.
And have you been known by your name? Have you been known by any other name?
No.
Where were you born?
Chicago, Illinois.
How far are you going to school?
Graduated high school.
Can you read and write understand English language?
Yes.
Another influence for you drugs or alcohol? Are you taking any medication?
Yes.
Is the medication that you're taking prescribed you using more?
Yes.
And have you already taken medication?
Yes.
Does the fact that you took medication and have you doctor board understand what you're doing?
No.
Are you suffering from mental condition or disorder?
No.
You understand why we're here today?
Yes.
You were charged with battery and law enforcement officer as a third-degree felony, punishable by up to 5 years in United States prison. Should that charge have its place?
No.
And you understand that battery is and what that means is if you pick up another charge of battery, even if it's a simple touch and it's going to be that could be charged as a felony as battery for that is a not. You understand that?
I understand.
And do you understand that by entering this plea, you're waiving your right to go to a trial by jury?
Yes, ma'am.
You also understand you waive the right to have the jury determine whether you're guilty or innocent?
Yes.
Right to hear state witnesses testify and have different questions of witnesses?
Yes.
The right to communicate on witnesses and submit evidence on your behalf? The right to testify on your behalf or choose to remain silent?
Yes.
And the right to state these charges not within the law. You understand that?
Yes.
Council, have you observed any matters for review? No. Sir, can you understand that you gave us the right to stay on all grounds except on this court and until this sentence?
Yes, ma'am.
I'm going to show you your 3-page score. You have your chief charge with your attorney.
Yes, ma'am.
And I set it for 22.6 points. That's one of the five years before taking on each charge. We believe this is accurate. And you understand that if you have been trial and found guilty on both these counts, you would actually have scored to a maximum of 2 years. I'm also going to show you a copy of a 2-page plea form. Have you ever considered this before?
Yes.
Did you understand it?
Yes, ma'am.
Have you discussed it with your attorney?
Yes.
And do you have any questions regarding the plea form that you want to ask the attorney right now?
No, ma'am.
And did you have a chance to sign that?
I did.
That is right?
Yes, ma'am.
And did you sign that to indicate that you are agreeing with this plea on terms and conditions that were mentioned?
Yes.
And if there's no
Yes, ma'am.
signature there, and you can sign that and take it satisfied with your term. Sir, other than what is contained in the plea form, or what we discussed today on the
Thank you.
I'm sorry.
other than what is contained in the plea form, and what we discussed on record today, any more comments or anything that's been discussed? Are you hearing this to the own today? Are you going to force or threaten by anyone? Are you thinking because you want to do this please in your own business? So do you understand that you're going to be placed on probation for 36 months? And you understand that there is no guarantee that you can full early terminate that probation?
Yes, ma'am.
And you also understand that if you violated your probation, that if the court found in a willful and substantial violation, that you should be specified in the court.
Yes, ma'am.
Are you satisfied with the advice and counsel of the attorney?
Yes.
Have you done everything you asked and answered all your questions?
Yes.
Counsel, have you reviewed all this coverage and evidence in this case with your client?
Mr. Perry has, I reviewed it separately and discussed it.
Okay, thank you. So is there anything you want to review in this case that you will not be able to review?
No.
I am unaware of any physical evidence that can be tested for DNA. You understand the result of this plea, no physical evidence will be tested for DNA? And you understand if you're not a U.S. citizen, you may be subject to removal or deportation as a result of this plea? And you understand if you are deported as a result of this case, it will not be a basis to withdraw the plea?
Yes.
If the incident you're pleading is sexually violent, or sexually motivated, to should be convicted of such offense, this plea may subject you to involuntary commitment as a sexually violent predator upon completion of your sentence. Do you understand this morning?
Yes.
counsel, you stipulate factual basis and legal for purposes of the plea?
Yes.
And you also waive the PSI?
Yes.
Your Honor, at this time, the state would ask the court to judicial notice of its file in 20 CF 1357, and that's time to state to
Okay, thank you. So the court will take judicial notice of case number 20 CF 1357. The court has reviewed the information in the file, does find that there is a factual basis for the plea and venue in Collier County. I'll accept your plea, find that it was freely, voluntarily, knowingly, and intelligently made and entered to the charge of battery on a law enforcement officer. The court will adjudicate you guilty, sentence you to 36 months of state probation. You will report today, and you will attend and complete an anger management course, 75 hours of community service, a letter of apology to the officer who will remain confidential, court costs, cost of prosecution, and $209 in cost of investigation payable to the Collier County Sheriff's Department. Thank you. Oh, and you have 30 days to appeal. All right, sounds good. Thank you. Okay. Good, thank you, Lisa. And there it is. Last but not least, one more. And that would be Miss Edna, is it Pina or Pina? Pina? Thank you, ma'am. Okay, this is case number 20 CF 1278.
No contest plea as charged for driving while license suspended or convicted traffic offender. The agreed upon sentence will be adjudication of guilt, 90 days in the Collier County Jail, with correction time served, which is 65 days. Responsible for 415 court costs, $100 cost of prosecution and defense, $431 investigative costs to the Collier County Sheriff's Office. And the sentence is to run concurrent with 2 misdemeanor cases, 20 MM 1939 and 20 MM 1123.
Yeah. Correct, Your Honor, and we ask the law monitor obligated for further questions.
Okay. We need her sworn in.
Raise your right hand.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth? Yes.
Oh, yes, ma'am.
Ma'am, would you please state your full name for the record? Sorry, what is your number? Okay. Thank you. And your date of birth? 1385. And the last four digits of your social security number? 4623. And have you ever been known by any other name or alias? No. Where were you born? Texas. How far did you go to school? 10th grade. And can you read and write and understand English language? Yes. And we are doing this plea over an audio video system as opposed to you being here in the courtroom. Are you in agreement with canceling the plea in this manner? Yes. Are you under the influence of any drugs or alcohol? No. Are you taking any medication from the doctor? No. Are you suffering from a mental condition or disorder? No. Do you understand why we're here today? Yes. You are charged in count 1 of the information. The driveway license is been revoked habitual offender. It's a third-degree felony punishable by a maximum of 5 years in Florida State prison. To that charge, how do you wish to plead? Good conscience. Do you understand that by entering this plea today, that there's no one here that promised you what the Department of Motor Vehicles will do in regards to your life? Yes. You understand that by entering this plea, you're giving up the right to a jury trial? Yes. You're giving up the right to see and hear the state's witnesses testify? And to have your attorney question those witnesses. You understand that? Yes, ma'am. You give up the right to subpoena and call your own witnesses and submit evidence on your own behalf? Yes. the right to testify in your own defense or to choose to remain silent, and the right to make the state prove this charge beyond reasonable doubt. Do you understand those rights you're given us?
Yes.
That's what I have reserved in the bench for.
I've not.
Sir, ma'am, do you understand that you've given up the right to appeal on all grounds except whether or not this court can sentence you here today?
Yes.
Have you had a chance to go over a police form with your, and a score sheet with your attorney?
Yes.
And you scored 14.1 points and to a maximum of 5 years in Florida State Prison. Is the score sheet accurate?
Yes.
And as to a plea form, did you have a chance to read over a plea form over there?
Yes.
And did you get a chance to sign it?
Yes.
Did you read over the form?
Yes, ma'am.
Did you understand everything that's on it?
Yes.
And did you discuss it with your attorney?
Yes.
On the back of the plea form, did you sign in 2 different places?
Yes.
Did you sign in the first place to indicate that you were, that you read over the form, you understand all the rights you're given up, and that you were satisfied with the terms and conditions of this plea?
Yes.
And did you sign in the second location to indicate that you're satisfied with your attorney?
Yes.
Other than what we have discussed here on the record and what's contained in your plea form, has anyone promised you anything in exchange for this plea?
No.
Are you entering this plea of your own free will?
Yes.
Are you being forced or threatened by anyone? Okay. Are you entering this plea because you believe, given the option, that you're in your own best interest? You have to answer out loud, ma'am, for the record, please. Thank you. Are you satisfied with the advice and counsel of your attorney?
Yes.
Has he done everything he's asked and answered all your questions?
Yes.
And do you understand that the plea offer states that you are accepted in 90 days in jail? You receive credit for the time served that your attorney mentioned on the record. And other than that, you understand that while you may be entitled to gain time or early release, there's no one here that can promise you that?
Yes.
I am unaware of any physical evidence that can be tested for DNA. Do you understand as a result of this plea, no physical evidence will be tested for DNA?
Okay.
And let me back up one. Counsel, did you review all the discovery in this case with your client? Ma'am, was there anything in this case you wanted to review that you did not get a chance to review before this plea?
No.
You understand if you are not a U.S. citizen, you may be subject to removal or deportation as a result of this plea?
Yes.
And you understand that if you are deported as a result of this case, it will not be a basis to withdraw this plea?
Yes.
Do you have any questions of your attorney in regards to that matter? If the offense which you're pleading is a sexually violent offense or a sexually motivated offense, or if you previously been convicted of such an offense, this plea may subject you to a voluntary self-commitment as a sexually violent predator upon completion of the sentence. Do you understand this warning? You understand that warning?
Yes.
Counsel, do you stipulate factual basis for bringing for purposes of the plea? You're also waiving PSI?
Yes. Yes.
Your Honor, this statement asks the court to take judicial notice of its court file in case number 20 CF 1028 and the Senate State. Okay, thank you. So the court will take judicial notice of case number 20 CF 1028 and has reviewed the court file, also your driving record. The court will find that there is a factual basis for your plea and venue in Collier County will accept your plea. Find that it is freely, voluntarily, knowingly, intelligently made and entered. To the charge of driving while license suspended, canceled, or revoked, habitual traffic offender, the court will adjudicate you guilty, sentence you to 90 days in the Collier County Jail, credit for all time served, which I understand is 65 days. You will pay all the court costs, the cost of prosecution, all applicable public defender fees, $430 in cost of investigation payable to the Collier County Sheriff's Department. These charges will run concurrent with case number 20MM1939 and 20MM1123. All costs will be referred to collections, and you have 30 days to place an appeal. Thank you. Thank you. And that's everybody.